more the custody to a de facto.
Okay, so before we start the medical neglect, we'll have Alina summarize.
No.
Role of counsel, come on.
Marina read it too.
I actually can summarize it.
Okay, go ahead. All right, what did you read? What do you want to talk about? Not so much the cases per se in terms of the facts, but the issue of role of counsel and how there could be conflicts.
The issue that I understood that the role of counsel is not just to follow what the child wants him to do. The role of counsel is more of finding this happy medium to see if the child is capable of really express their wishes or what he thinks is better for him or it serves his best interest, then the counsel's duty is to follow that particular wish.
Okay, so Alina's saying if the child is capable, mature enough, etc., to understand the legal proceedings, and capable and mature enough in other ways, then that child could have a conversation with you, and you could decide how to proceed, what kind of legal strategy they do have. But that's the easy cases, right?
Right.
What are the hard cases, Marina?
The hard cases is that as a lawyer, the counsel is supposed to predict what the child would want and then defend his interests.
Where does that requirement come from in the readings that I gave you? And it's called a client-directed model, and it's a combination of what Alina just said, and along with that, the child who is not mature enough, etc., you should be able to predict, or you should be able to determine what that child would want if the child were mature enough, etc. But where does this client-directed model come from in Massachusetts anyway?
I got it from the article that was published in the Boston Bar Journal, The Role of Counsel for Children, a proposal for addressing a troubling question. There was 3 different models there. The first model was focused on child minority and thus received, and childs were considered to be incompetent. And if the child is competent, the lawyer could decide for child what is the best interest of his to pursue. The second set was the guardian ad litem, where the lawyer is guardian ad litem, and whatever the child wants, he just being a voice for the child.
Now, in the sexual abuse case that we dealt with in the role-playing issue, I touched on it a bit. In the real case, an attorney was initially appointed for all 3 children, Alicia, Jason, Jonathan. At the time, I think, remember I said to you that Alicia didn't stay with the grandmother, she went to Uncle Tony, so they were all with Uncle Tony. And the district attorney's office had set up an interview after the SANE. They had what was called the SANE interview first, under Chapter 119, the group of professionals to get together to question the children. Not that first leading interview that the social worker and the policewoman did at the children's home, but they set up this interview, and the children, it was at that interview that the children, recanted and produced that other shower story, right? Well, after that, the district attorney's office said, I want the children to come down, all right? So Uncle Tony brought them, their court-appointed lawyer met them there. Uncle Tony sat in and apparently didn't like what was going on in terms of district attorney started to, ask them questions, and was in the process then of investigating and trying to determine whether to prosecute Lee. Because remember, at the time, he had only been arrested and appeared in court for the case where Justin was the victim, right? Well, Uncle Tony got angry and said, we're going home, I'm firing you, to the court-appointed attorney. and then procured private counsel for the children. DCF at the time was in an uproar over this. They brought a motion before the court, blah, blah, blah. They were saying there were, ethical violations, this and that. And the judge, and again, this was an older case, so some of the requirements that I gave you, like the CAPL, the CPCS, Committee for Public Counsel requirements, those weren't really in effect the way they are today. But anyway, in the argument before the judge, DCF is saying they shouldn't have this private attorney. It's really dad that's directing all of this because it's his brother, blah, blah, blah. And apparently, I think that the judge kind of didn't know what to do. Like, oh my God, what do I do? I mean, they as clients, the children, have a right to have whatever attorney they want. Under Chapter 119, one is appointed for you if you can't, afford counsel. But according to Tony, he's saying, well, I'm paying for their counsel. I didn't like the way the court-appointed counsel was, subjecting them to another interview. It was traumatic, blah, blah, blah. So the judge then appointed me as the guardian ad litem. And so he saw that conflict that you guys are reading about in these articles and in these cases, the conflict between what the child wants, because Alicia and Jason at that time had recanted, were saying, we want to stay with dad, this never happened, this is what we want you to do, versus what really might be best for them to be free from, any further abuse if in fact there's sexual molestation and even rape, going on. So he appointed me as guardian ad litem, and I remember at the time I took them to the notes. He has since died, and I forgot his name. He's really famous. Happened to be a JD and also a psych person. I'll remember at some point and give it. And I remember him saying to me after I took them for their initial, talking to, that they were the toughest clients or the toughest kids, and I'll tell you in terms of what that he had ever seen, because the way that they stuck together and were adamant and firm about what they wanted. So it turned out that the council, the new council, who DCF said was acting inappropriately, really wasn't acting inappropriately in terms of the client-directed model. It doesn't look like you get a iffy feeling about it. Oh, these kids that supposedly be sexually abused, you have their attorneys, actively advocating against DCF. But that's our model in Massachusetts. And some states are different. Some states have a combination. Some states have the true, like the guardian ad litem model. For example, the article that I co-authored with Judge Blitzman, children's attorneys, should they be advocates, client-directed? We do what you want, even if what you want is so unpopular, so terrible, or should we be champions, the best interest model? So I like the fact that in Massachusetts, there was that luxury of when a conflict like that came up, that the judge could say, okay, you can represent them that way if that's what they're saying, but I still need a GAL on the case. I don't know in your future, if you're attorneys in the next few years, what's going to be happening in terms of representation of children in the court system, only because of the economics that's going on. Marina, you want to say something?
I just wanted to add here, because in this case, it's an adoption of America, Massachusetts case, and there is basically what is noted is even where it is undisputed that the child and her attorney disagree, the law is unclear as to whether the attorney is always bound by her minor's client's decision when the attorney feels that the child's decision is not in her own best interest.
Right, and that was an earlier case. Now, Georgette, go ahead. Finish your point, I'm sorry.
That's fine. The point is that we still don't know.
Yes, although Georgette came after that, and even after Georgette, supposedly there's this study going on in Massachusetts. I'm not even sure what's happened with that study. I remember the judge told me once, I'm going to put our article in the study. Yeah, all right. again, if you're gonna become counsel and as a private attorney independent contractor, where the state will be paying you, the state meaning the Committee for Public Counsel, you must follow the requirement of the client-directed model. So even if you represent an infant, in this case Jonathan, by the way, even though he was not directly involved in any of this, you know, there's case law, and you've got some of it that the court really doesn't have to wait for abuse to occur. You know, if the facts and circumstances show that that particular child would also want to be free from harm, you know, if that became your client-directed, you know, model, your strategy, then you would be advocating, or the state, certainly the state would be, and did petition the custody of that child as well, even though that child was not, you know, being abused himself. That's another issue. I just meant to bring it up, and I don't know if we did last week. Yeah.
Can I ask a question that's completely aside from this?
For the Counsel for Children issue?
It's more on the, I have a mandated, I watched a show yesterday, I'll make this quick, Dr. Phil. And it was a man that was admitting to being sexually aroused when his daughter was sitting on his lap.
Really?
And that he had had fantasies of molesting her.
Okay.
The wife's, of course, sitting there going, I know my husband needs help.
Okay.
So I'm wondering, I'm watching this wanting to vomit. And where, I mean, this is on, I can't even, you know, hopefully someone gets him walking down the road. Because I'm like, I can't believe this man's sitting there talking about how he's getting sexually aroused,
Right.
but doesn't trust that he's not going to molest his daughter, who's like, I think at the time that the show went on, she's like 7 or 5? I think she's 5. Where would any mandated reporter watching that have to do anything, or any, I mean, who's gonna do something?
I would think if he's saying it on national TV, that he may have said it, or maybe people in the family, neighbors, school people may sort of already know about it.
They do.
So there may have been,
done.
you know, you don't know that because
Right.
this is all confidential stuff. There may have been 51As, you know.
They said that the wife said that she had no support system really, and she just did the best she could to try to protect her daughter. But, so say nothing had been done, would any mandated reporter watching that, or anyone in the show, or Dr. Phil himself, I mean, is anybody required to report it to, I mean, everyone's thinking, did anyone else
on
see
the
it?
jurisdiction, but,
So,
you know,
it's not
every
that-
mandated report, the mandated reporters in other jurisdictions are similarly situated in that if you've got reasonable cause to believe that a child is in danger of abuse and neglect, then you should. So maybe, the answer is maybe.
I know,
Yeah.
so like I
Yeah.
said, it was off
Yeah.
a little bit, but I'm just
Yeah.
wondering how, you know, as you're
Right.
talking about Jonathan
Right.
not being touched yet.
Right.
And this little
Right.
girl hasn't, as far as what he was admitting,
Right.
had not been abused
That's
yet.
interesting.
What protection
Wow.
does she get?
Crazy thing.
You
to
gotta
see on
watch
TV.
that. He was, pretty tapped.
So
Yeah.
those are the issues surrounding the whole Counsel for Children. Now, I mean, if you encounter as, you know, suppose you represent a child in the context of a case like this, and the child is telling you what he or she wants, and, you know, you think the child is mature enough to understand that, but yet you have that awful feeling, you know, but you've got to do, you have to represent that person in what he or she wants done legally. But the ethical dilemma is that you can't really divulge confidentialities of your client. So you can't say to the court, Judge, you know, my client wants to go home. I think if she goes home, she's going to be sexually abused. Therefore, why don't you appoint a guardian ad litem? So hopefully, and most of the time it happens that the court recognizes the issues, and the judge on his or her own, you know, recognizes that somebody has to be there for the best interest piece of it. Yeah. I
Can
think
you, as an
it's-
attorney, kind of help the court to shed that light on what's going on conflict of the interest that you're not really representing your client by just asking a question, or maybe cross-examine your client in order to
I think the
what to
easiest
see.
way to do it is to just keep telling the court, Judge, my client is wanting this. My client is directing me to. So the judge is clear about what the child is saying he or she wants. And then the judge has access, you know, through the other parties and whatnot to all this other stuff. And the judge, okay, well, what about a guardian ad litem? I think we might need one here. Yeah.
Well, what is the percentage of actual private counsels working with children in these situations or versus court appointed? Do you see more court
Court appointed.
But it doesn't
for
matter,
sure.
it's either way, they still
Yeah,
have the
yeah,
same
yeah.
obligation to their client, whether they're
That-
privately
That's right.
hired.
That's right.
But maybe less.
Yeah.
You know, I know as a private attorney, they're not supposed to listen to the person.
Because think
Paying
about
them.
it, you know, private attorney in the Uncle Tony situation, it looked a little kind of iffy there, you know, oh, Uncle Tony's paying. Well, that's okay, but if truly it's Lee that's paying or Lee that's sort of directing it, you know, that can get scary. And young children can't ordinarily afford counsel, you know. So in this case, it turned out to be, you know, according to the judge, you know, he let it go because Uncle Tony was saying, you know, he was paying for it, he was directing it, etc. They were living with him at the time. Father was not having access to them, by the way. He was getting scheduled supervised visitation in DCF offices.
But
Yeah.
couldn't the father, I mean, he had lost the temporary custody at this time. The
Right,
Uncle had
right.
it. But still as a father, did he have the right to hire counsel for his, because if you look at the ethical rules in Massachusetts, I'm not sure if those were out at
I
that
know,
time,
you
the
have the
same
right to
one.
hire.
That a third party can, but yet you don't have to, you know, they're not the client. Do you think he would have been allowed to have, I mean, if that had gone
Right,
to courts above?
Right, that's an issue, isn't it?
Because he's still
Other
their
than that.
parent.
Right. Right. It was a tough case and many issues. By the way, there was one that I didn't even tell you about. At one time, we had a girlfriend with a son, and I think at one time, you know, custody kept going different places. And at one time, they were with the girl. No, they weren't with the girlfriend. Hold on. They might have been, I can't remember. No, they weren't. She had a son, and she ended up filing with pay. You don't want to hear it. This is just.
He's in jail still, I take it?
Yeah, probably.
Okay.
All right, let's move on to medical neglect. Because what I want to do is just have you guys summarize these cases, and we're going to do the IFA mock presentation on Thursday. We're going to skip the mental health issues. I usually have a speaker, and I haven't even contacted him, and I may not. We may skip that section entirely just because of the snow days we had and whatnot. So, in Ray McCauley is the first case. Whoever did read the, Daniel, you said you did move on to the medical neglect, right?
Yes, I did. read
Okay,
all of
do you want to
these.
talk about McCauley?
Well, let me try to, this was.
Notice this wasn't, you know, who brought this case? So this wasn't like the cases that you've been reading, which were Karen Protected
Wasn't this the
cases.
doctor?
Yeah.
The doctor had brought this?
Or the hospital, rather.
Just trying to this is the one with the child that had leukemia,
Yep.
and I'm just trying to, sorry, I usually write out briefs and I didn't write them out.
Do you want to do the next case and I'll call it?
No, they were Jehovah's Witnesses, and I think that the Jehovah Witness that I got from the cases was they felt that if they had a blood transfusion, then that something about them just not being pure, or being able to, okay, and so they were refusing.
Norman, say that out loud about the
They-
blood thing. Tell everybody.
And because it comes up in another
Yep,
subsequent
yep.
Well, we read a lot about, no offense if there's one of the Jehovah's in here, but we sure read a lot about, you know, anyway.
You do, because of their religious convictions, but
Yeah.
remember Prince was the Jehovah parent that lost in the lawsuit regarding the state because she was having her child hand out those pamphlets. Whereas the Yoder case, the Amish parents won in the lawsuit against the state for taking their children out of school. And so, you know, compare those two religions. You see a lot of these Jehovah cases. I don't know if any Jehovah cases that have been decided by the appeals court or the SJC have been in favor of a Jehovah Witness. And the major difference seems to be that you have Amish and you have Christian Science people too. They're more established, you know, they've got a lot of lobbying behind them. They're more powerful. I mean, that's my take on it. So I feel bad for the, you know, little religions. Not that it's that little, but you know what I'm saying. So go ahead, Danielle.
This was, so the child had a blood condition, I believe, and that the leukemia, in order to, she needed a blood transfusion. It's something to do with her heart failure also. The parents just said no, they weren't going to do it. So they filed a case in order to have the parents bring her for the blood transfusion. And out of what I found through most of these cases, they had three different things the state needed to establish while going into court, which was, one was the natural rights that we know that parents have, the fundamental rights parents have. And then you have the interest of the child, and then you have the state's interest.
Yeah, so the triangle that we talked about from the beginning, and how do you balance that?
Well, the way they balance it in this case, some of the other cases, is that it seems like the child's interest and the health and welfare of the child and the state's interest always seems to outweigh the parents' interest, their refusal of the medical treatments of the children, of the child in this case.
The footnote, if you have them, 5 factors.
Yep.
Okay.
They applied the best interest case, they applied the best interest test, and the 5 factors that they found was the child's age, the risk to the child's health and life, if the requested treatment was not ordered,
Yeah.
the real probability that the child's illness would be in remission if she was given the requested treatment,
Yeah.
And the treatment of her dangerously, well, that's the leukemia, a substantial chance of a cure in a normal life for the child if she underwent this recommended treatment,
Yeah.
and then minimal risks of the child's health that would result from the treatment.
Mm-hmm.
And then it went into the 3 interests that the state has if a dangerously sick child receives medical treatment over her parents' objections. The first was the state has an interest in protecting the welfare of the children within its borders. The second was the preservation of life. And the third was the medical profession is trained to preserve life and care for those under its control. And I think the judge had found that without the chemo, that she was going to die if she didn't receive the treatments, the chemotherapy, the blood transfusions, and those. They were ordered to have her receive them.
Okay. That's it. Custody of a minor. Okay, Heather.
This was a case where the child had leukemia. He was 3. And he was getting chemotherapy. And the parents stopped giving the medication.
How did the parents in this case differ from the parents in Macaulay in terms of their rights, their
Oh.
Were they Jehovah's? Were they
No.
arguing some sort of religious
No,
interest?
they were, right, they
Okay.
started the chemotherapy.
Yeah.
And the child went into remission when he was on the chemotherapy. And unbeknownst to the doctor, they stopped giving him the medication.
They meaning?
The parents.
Yes.
The parents stopped giving the medication to the child,
Mhm.
and he went doctor, in finding out that they stopped giving the medication, the doctor brought the parents to court in order, you know, to.
Now, this is a custody case.
Okay, so,
Right,
right,
so-
so it's actually then the department.
No, you were right about the petition.
Okay.
Remember that under 119.24, that anyone could petition
Yes.
in a care and protection case. So who was the petitioner?
Oh, the petitioner then was the doctor.
Yeah, but it was,
Okay.
but unlike Macaulay was started in Superior Court. Custody of a minor was a custody case, was a care and protection case, right?
Right,
I'm
okay.
trying to differentiate between the two, go ahead.
Okay. You know, basically stating that to start the treatment again for the child. And, you know, so they went to court, and essentially it was the same kind of analysis as the prior case as far as the interests, the child's interest versus the parent's interest and the state's interest. You know, Truman said that the argument on the doctor was that the only way to keep this child in remission would be to continue with the chemotherapy, where the parents argued that the child was suffering from abdominal cramping and constipation. So that's why they opted at that point to stop the chemotherapy. However, the doctor stated that the child did not seem to be in any real discomfort, you know, that chemotherapy usually causes. So, and the complaints that he was having, they could adjust the medication and therefore solve those problems. And the only time that he did go out of remission was at the time when the parents stopped the treatment.
Coming back again to the allegations of 119.24, so the state can intervene when it's a situation that where parents that truly do love their children and, you know, aren't abusing them or anything like that, but for whatever reason, whether it's religious as in Macaulay or in this case, you know, for their own 14th Amendment sort of rights, I can bring my child up and make my decisions and so forth. But if in doing so they're endangering the child's life, then the state can intervene to actually get custody so that then the procedures can then be done. All right, so that's the first case. I want to just go through these because the next case, maybe Elizabeth, you can talk about the next case? It's the same case decided a year later, custody of a minor number 2, the same kid, Chad Green.
That's great, Deidre.
Well, it's the same, these 3 cases concern the same child. His name was Chad Green.
Okay.
So if you have custody of a minor, let's do that one next.
Okay, that's the second one.
Yes.
Can I do the Greenwich Truman?
Oh, yeah, I was saying, yeah, that's fine.
I can't find where I pushed it.
Custody of minor 2, the 1979 case, Norman?
Yeah.
Yeah.
That was the folic acid cocktails and stuff.
Laetrile. Now, again, I didn't know if these cases confuse you, but it's the custody of minor 1, custody of minor 2, and what's the other one called? Green v. Truman are the same child, the same family. So yeah, tell us about this Laetrile drug that the parents wanted to use. Norman, if you can see your computer.
No, I was just, no, I have the cases here, and I was just trying to, okay, because you confused me, so it was, well, it's a perpetual state. So the parents.
Because now we're at the point that this case went to trial, and now the SJC is reviewing the findings of the trial judge.
Was the custody given to the state after the
Yes.
first one?
Yes, in order, again, to do
Effect
that.
the treatment.
Not
Yeah,
physical
yeah.
custody.
Not physical, and that's
Legal
the
custody,
point.
right.
So Chad is still living with his parents, but the order is for custody in order to get the medical treatment. So, go ahead, Norm.
So, what they have been doing, they've been doing this called metabolic therapy, which consists of some treatments that are advocated by certain people, but not necessarily established in the medical community.
Right, why
And-
not?
Well, I mean, I think that, you know, one of the big reasons in this Laetrile, I think that there was an issue with the instability of it, that it could be, what was it?
What does not consistent with medical practice mean?
Well, I mean, the medical community says that, you know, the most effective way to deal with this, with leukemia is chemotherapy, the three-phase treatment, and it has a high probability of success if the treatment regimen is followed. And I think in that, the first Green case, that because they took him off the medication, that I think they lessened his chances to like 50%. But, so, well, you know, this guy, the parents have, I don't know, I guess, you know, I guess some people would probably call them quacks, but, you know, they have 4 expert witnesses come and testify as to, well, originally they testified, but a lot of them seem to go back on their testimony, saying that, well, you know, it's supposed to do this, but, you know, then it's really not gonna do this, it's gonna do this. So with, does that answer your question, that, you know, that it's not chemotherapy, it's an alternative approach to treating leukemia, which is not accepted, it's not the accepted protocol.
At least in Western, when compared with Western medical practices in
Yeah.
the United States.
And so the big thing with the Laetrile is that it's 6% cyanide by weight, and so, you know, this kind of, you know, lost me when it combines with something else, it can be safe. You know, it's talking about to form a molecule of benzaldehyde and a molecule of hydrogen, and I, you know, tried to ask Elizabeth, but she wouldn't answer. She wouldn't tell me, but so I mean, there is.
Chemistry was not her major.
No, I'm just, you know, trying to, you know, not look dumb, but
It's really working.
well, sitting next to you, I was hoping that.
What was the week, who was suing who? What were they?
Alina wants to know who was suing who.
Well, the family wants to be able to use their.
Different alternative
Yeah,
methods
yeah.
to treat.
No, you didn't answer Alina's question.
The parents are going to.
It's custody of a minor, it's the same case, I said,
They
right?
already decided.
No, it was not already decided, right? Because, Kelly, you summarized custody of a minor 1.
Right.
What was the holding of custody of
And the
minor 1?
holding was that the state would have custody of the child specifically for the medical treatment. Physical custody remained with the parents.
The
And
state may intervene.
yes, and the state may intervene to be sure that the child gets the chemotherapy required.
Now, the case remains open, right? Because the child is supposed to be getting the treatment.
Yes.
And then Norman tells us that next thing we know, parents are starting this whole Laetrile metabolic, blah, 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 and the state doesn't like that. The hospital doesn't like that because the child's gonna die. The
And they
case then
have,
goes to trial,
It's like,
and as
what is
Norman
it?
says, the finding of the SJC, the holding of the SJC, Norman, is that what?
You can't do it.
Can't do it
Yeah.
because it's not consistent with medical practice, it's not in the best interest of the child. Then, Elizabeth,
So then
and
the-
actually then, I'm sorry, but, you know, I didn't put these in order. That's all right.
This was a
Green v. Truman is a federal district court case. Still the same case, they were all decided at the same time. I think by the time when Green v. Truman was decided by the federal district court, which is just a trial court, the custody of a minor case was still going on. So tell us about this one.
So this was in 1978, and now the parents are bringing civil rights action because of they say it's their constitutional right to decide how their child, Chad, gets medical treatment. And so there's motions to dismiss that are being filed here. And the district court judge, he found that the prior action,
Meaning
the decision.
the custody
The
case.
custody case, with the state providing the chemotherapy is fine. That's not a constitutional deprivation for the parents. And then
What does it mean when the district court here states that the parents were stopped from raising the issues in this court, meaning the district court?
since they were already decided, the decision.
They raised
stands.
those same arguments in the context of the custody case.
Right, so they can't bring them back. In
Anybody?
a subsequent action.
Was anybody around or anybody remember this case and what the outcome of this case was? Very sad, because the parents ultimately fled to Mexico with Chad and wanted,
What happened? I'm
to
sorry.
continue the treatment, and he died. I forget how old he was at the time.
It seems like if they'd done what he was.
What's that?
It seems like if they had done what was going on, I mean.
But think of it this
the
way,
chances
again.
of
The
life,
reason is,
so-
it's parents that, for whatever reason, religious or otherwise, are feeling that they're doing, it's their family, and the state shouldn't interfere, when you read the early cases, that they're doing what they feel is best, whether it's for religion or other issues. You may have families that have been brought up as a different sort of practice than Western medicine. We think that Western medicine is so established, but in the context of the history of the world, there are, other ways to treat children and people besides, radiation, besides taking blood, besides taking pills. Some parents think that natural is the way to go. Others, are raised on some real traditional, principles. And you'll see that in the Iger case that we do on Thursday.
Do you think too that these parents might, they were living with him and he was going through treatment when they started taking him off of it, and I wonder if, if you're not in that situation dealing with your own child the chances of him living taking the chemo, if I remember, was only like 50% anyway, so half the chances he's gonna live, but the other half the chances he's going to die, and maybe they felt like they needed to, they're not medical professionals, maybe they felt like these other things people were telling them about weren't really going to save him.
Some believe that the quality of life would be better, no matter how short that life might be, without the intervening medical procedures. Chemotherapy on a child, as I've seen it, is terrible, terrible. They're already sick. They're already this sick. Can you guys see it online? I'm holding my hand up just a little bit. They're just a little sick, and they're way, way sick in order to get better. but it's a long, process. Some don't want to see their children suffer. So there are many reasons, and again, it comes back to the rights of parents, the rights of the family. And that's why these cases are probably the most sad, because they have parents that they're suitable for every other reason, but the state is saying that for this reason, they're not suitable. And the state has a right to intervene to save a child's life and so forth.
Do you think that's right? Do you think that because, and I don't know if alternative treatments work.
Right.
I mean,
Right.
I had a cousin that went to Mexico, something about avocados, and she died within a year.
Yeah.
Because she didn't want it, but.
Was she an adult or a child?
She was an adult. She had breast cancer, and that was her form of alternative treatment.
Right.
And a lot of us felt, why are you not doing everything you can to save your life? But is that really, is chemotherapy and the medication, I mean, is it right that the state says,
Right.
this is the treatment you have to use? You can't take this child to another country or use an alternative.
Yeah.
I mean, and this is usually how they would rule, I would expect. It's a
Again,
recent case with
using the five, those 5 factors that you pointed out in the
Yeah.
Polly case.
Yeah.
So it depends on what's going on with that child, how old that child is.
And when do they have a voice?
What is the health concern? What are the probabilities that with the treatment, the child will survive, not only survive, but what kind of life will the child have, afterwards? So all of those things are still looked at.
Wasn't there a case last year that had was he 16 or 17 years old, when the mother ended up taking off with him?
I think
That
so.
they were, I mean,
I
that's.
don't remember what happened with that case, but yeah.
I wonder at what age they're allowed to make their own decisions. It says age is one of the
Well,
factors.
if you don't mind, let's jump to Rena, because that was exactly, Alana, you want to do that?
Sure. She was 17.
She was 17.
Yeah.
Yep.
Fine.
Rena.
Rena, in-grade Rena?
Yeah.
We'll come back to, where you brought that point up. She was 17, you
Yeah,
said?
she was 17. I'll just go from memory.
Okay.
So yeah, so she was 17. She was a Jehovah's Witness,
Mhm.
and she got injured severely in a snowboarding accident, I believe.
Mhm.
And when she was rushed to the emergency room. When she got to the hospital, they had determined that a blood transfusion may be necessary,
Mhm.
based on her condition if something happened, to some extent. Both she and her parents, it was her parents, but she also made the decision, as she has been a Jehovah's Witness, basically her entire life. She refused this blood transfusion. I believe, was she the one that had signed several documents stating that she was aware of, that she was aware of what could happen to her, that she might even die if she did in fact refuse this treatment. I believe she signed several documents to that extent, so she was confident enough to sign those. And she didn't end up needing the blood transfusion because she got better, she got released from the hospital. So the court said this case was moot.
This case was moved because
Yeah.
she had already been discharged and she didn't need it, as you
So
say.
we
But
ruled
what-
that way, not because we agreed
Exactly.
with it, but because it was no longer relevant.
And what the court pointed out, actually, there were 6 factors the court talked about if you have it relative to the best interest of a child in a situation like this. I'll read it if you want. Okay, go ahead.
Okay, so the 6 factors are the patient's expressed preferences, if any.
Yeah, so you're looking at, the court would look at if that was the case, if that didn't become moot. Rena saying, I'm 17, I'm a Jehovah. What's the second one?
The religious
That's
convictions.
the religious conviction. I'm 17, number 1. Number 2, I'm a Jehovah.
Yeah,
What's the third one?
The impact on the patient's family.
Yeah,
So
and
we
they
feel
were all
like
Jehovah's,
parents,
so-
right. Exactly. For the probability of reverse side effects from the treatment, there are known side effects to blood transfusions
Okay.
that could have been used. 5, the prognosis without treatment. Well, she would have died if it was.
So that would have been really important in terms of do we listen to what she has to say and allow her not to have the treatment if the prognosis is that she might die or becomes, yeah, okay.
And then the present and future incompetency of the patient in making that decision.
Okay.
Well, she was confident enough to sign.
Right.
But she did refuse to be treated, right? And
Yeah.
she didn't die.
And she didn't die, but again, you had the appeals court sort of say, we'll talk about this, but the case has become moot because, she didn't need it, and she left, so. Let's come back to Twitchell. I know I'm jumping around. That's a criminal case. Does anybody remember this case? No? They were the Christian Science parents. Now, there had been, and I forgot if we still have that on the books, or if it has changed, but there was a statute that Christian Science has what's called a, something practitioner. I just call it a practitioner, which is a person that will come and help you pray when you're Norman, stop shaking your head when you're sick. So there was, remember I said that they're big lobbyists, that Christian Science religion is very powerful, so there was a Mass General Law statute that said that when children did become sick, that Christian Science parents could treat their children with prayer. The problem in this case was the child had, I'm going to let somebody take over for me. Who's read this case? The child had what? Ash?
I didn't read this.
Okay.
Lily?
He had like a perforated bowel.
Which can be absolutely life-threatening, right?
Yeah.
And?
There was, well, the parents were relying on some statute.
That's exactly what I was just talking about.
Yeah.
Yep. Mhm.
You know, that they would be basically absolved from responsibility, because they could just pray and whatnot.
So how long was the child sick? I don't know if it's in this case or not. If at all, you know.
It was like a short
Well, it died at 2.5.
I'm sorry?
Right, he died at 2.5.
At 2.5 years old, or day
Yeah.
2.5?
April.
2.5 years old, and
5 days.
5 days he was ill, that's what I was getting at, okay. And so
Okay,
those
yeah.
5 days they were treating him with prayer,
Right.
and then he died on the 5th day, 6th day, you know?
Yes.
Okay. And then they're prosecuted for what?
Manslaughter.
Okay.
Voluntary manslaughter.
Yeah.
And, the court was just, saying that parents, they wouldn't be exonerated just because.
So why does the SJC uphold the manslaughter convictions?
Well, because they neglected to care for their child, they had to.
But they had a statute that they were relying on.
Didn't it seem to be affirmative defense too? Didn't they have to plead it?
That was true. Yeah, well, they didn't get an opportunity to do that, put it to the jury, so it's like.
The SJC does say that's harmless error.
I thought they still reversed.
I'm sorry?
They still reversed that case?
Why?
They reversed it over their, it had something to do with the lack of knowledge and the prosecutor speaking out, or the attorney general, and the way that he spoke out. They felt that they weren't going to, that they wouldn't have consequences. I'm trying to find the highlighted sections
It's
of
like
it.
they were saying that they reasonably relied on that and whatnot, but it's.
Was the conviction reversed or not?
Yeah.
It was?
The
Do
reason,
you
for
all
the reason
agree?
the judgment must be reversed, the verdicts must be set aside, and the case is remanded for a new trial.
Or remanded for a new trial?
Yeah, they had been convicted, and it was sent back to try again.
By the way, there was a new trial. They were still found guilty, but they didn't do any time. No, they were still found guilty of voluntary.
I wonder if
And that's why the case is important, because the duty to seek medical attention at some point, that's why I was asking really how many days, at some point overrides the parents' the parents' rights to treat their child with prayer. So they're relying on, not only their own 14th Amendment rights that we talked about, not only their religious rights, but a statute as well. But that only goes so far. When the child becomes truly in danger, you've got to seek medical attention. So again, you could be criminally prosecuted for not seeking medical attention. So now we've seen the Superior Court case where the hospital sought the treatment, the custody cases where parents lost at least legal custody, so children could get medical treatment, and then now a criminal case where parents could be prosecuted for failure to obtain medical attention. Can we go to the Cobble case? Because the Cobble case, the procedure of the Cobble case, I want you to understand, because that's the forum for the role-playing exercise that we're going to do on Thursday. So who can explain procedurally what was going on in Cobble? What kind of case Cobble was? Where did it start?
What was the 51A? It was a 51A.
Yeah, the nurse in school, no, the teacher in school.
So who's starting? Does that mean Elizabeth or Norman? There was a teacher in school, you said, in a 51A.
Well, I don't want to steal her
Okay.
thunder.
I got that part.
So, let's see here. So the teacher filed the report, and this was with the boy who had been spanked with a belt, I want to say.
A boy had been what? Spanked with a belt by his dad.
father. And, so.
How did the teacher know
The
this?
teacher just suspected. She
Mhm.
didn't actually see any bruises or markings on the child. She said that he appeared more depressed and angry,
Okay.
and that he was having difficulty in class, and so the father admitted to hitting the boy with a leather belt on 5 or 6 different.
Okay, so you had a 51A,
Yes.
mandated reporter, school nurse calls DSS, DCF, DCF starts investigating 51B,
They sent
so they
it-
talk to dad, and dad says, yeah, I hit him.
Yep, so dad talked to the department social worker, and, who separately interviewed the boy too, and the boy's mother, and 2 of the boy's doctors. So the dad said that he hit him, and
Okay.
then, both the boy and the mother confirmed most of what the dad had to say. The mom, the dad basically said that he was doing this because of the kid's bad behavior in school,
Okay.
and that such type of discipline is required by the Bible.
Okay.
And so the mom went on to saying that the father is nonviolent, he's controlled, and the boy, expressed that he was fearful of it and disliked the spanking, obviously, but he understood that it was his dad's way of teaching him a lesson, and that his dad looked at it as a requirement by the Bible.
Okay, so all of this that Elizabeth is summarizing would have been in the social worker's 51B investigation report. Okay, so what happened next?
So then the doctors were interviewed too, and
Okay.
the boy had a muscle condition too. So the doctors were especially concerned about the spanking that the dad was doing, and
So at the close of this investigation, what does the social worker find?
so the social worker found that the use of this type of corporal punishment
Mhm.
put the boy at risk of physical harm and wasn't acceptable.
And what's the magic words here? What standard? By what standard did she reach that decision? Anybody can shout it out.
Substantial
No, that's later on.
That's the standard.
So this is just the social worker investigating the initial report?
Basis?
Huh?
Reasonable basis.
I don't know why everybody says basis, it's reasonable cause.
Reasonable
Are you
cause.
seeing basis somewhere? I'm just
I don't know if
wondering.
we get that.
We're thinking rational basis.
Okay, no, it's reasonable cause. So remember, reasonable cause for the mandated reporter to report, and also now reasonable cause for the social worker who did the investigation to substantiate that report. So all she's saying is, yeah, he hit him, there's reasonable cause to believe that, you know, that was abuse, all right? So then, what happens next?
And then they
So
had-
that decision is made, that's a DCF decision to support the initial report of abuse. And then,
And then there was an administrative hearing,
how? How did that come about?
and so the department held the hearing,
Why?
to review the social worker's
Why?
decision.
Why? Who wants that hearing? Who wants the
The
hearing?
father wants
The
the
hearing.
father. So that's his right. Remember, this is the agency. This is the agency acting as a quasi-judicial body. And this is the parent who has a right to review of a decision made by the agency. It's called the fair hearing. So, go ahead.
So she testified, the social worker testified at the hearing,
Yeah.
and, let's see here. Although there wasn't, like I said before, there wasn't any skin bruising or tissue swelling or anything, the department still found it to be a form of physical abuse under their regulations.
Are you talking now about at the conclusion of the administrative hearing?
Yes.
Okay, so you started to say before, you had the standard. What's the standard
And
at
the
this?
standard of review is substantial evidence.
Okay.
And that is defined by statute, that such evidence as a reasonable mind might accept as adequate to support a conclusion.
And where does that come from?
And that comes from General Law, Chapter 30A, Section 1.
30 is the Administrative Procedure Act, so any agency, and it happens because the department is an agency, is also governed by that act. So if you're a claimant like the parent in a abuse and neglect situation, you have the right to go through all of the administrative channels before you go to court, and he ultimately goes to court too, right? Because
Yes.
that's why you're reading the case. What does he do?
So,
I'm assuming he appeals that decision, the administrative hearing, right? And he goes where with that?
and then he goes to trial court.
Yes, which, absolutely. Because you've gone through, you've taken all your administrative actions. There's nowhere further to go, and the agency is still saying, we're right, we're right. Well, you're like, no, you're not right, you're wrong, you're wrong. So you have the right then to go to a court for review of that agency decision. So he goes to where, Norman?
It's a superior
He
court.
goes to Superior Court, files a lawsuit against the department, right? And what happens with that lawsuit, Norman?
That lawsuit was, they found in favor of the father. Because
Who's they, wait, we're still at Superior Court.
I'm sorry,
Before you get to,
the Superior Court found in favor of the father that the evidence wasn't there that substantiated.
the Superior Court?
I know that it was,
What does the trial court find? The Superior Court, not the SJC.
oh, I'm sorry, I had that wrong, obviously. By judging from your,
Tone of my voice.
it was I was thinking of the big court.
Because what's the Superior Court doing? Every stage is a reviewing stage.
Right.
The Superior Court is now reviewing
They affirmed
the
it.
agency decision that Elizabeth just summarized.
They affirmed it.
And so the Superior Court judge affirms the agency decision, then Cobble does what, Norman?
He
takes it
goes
up.
to it goes to the SJC, and they say that it's not even a close decision for them, that the evidence.
Why
was-
not? And what standard does the SJC use?
They said that, well, what they said, I can't repeat to you.
The SJC?
No, because I don't know what it is.
Oh, Alina?
Some
Clearly
sickle cell.
erroneous.
Clearly erroneous, because why?
That's the,
Substantial evidence.
Again, the SJC is reviewing the substantial evidence standard and finding that the court below was clearly erroneous in reviewing that standard and affirming it. So you have a case of the father who's, and by the way, what we didn't mention is that Elizabeth, once the report was substantiated by the social worker, did DSS take any further action? No. They said, okay, you slapped him. That was abuse. Do you need any services? No. Okay, we'll close the case. So if that was the case and the department, and that was the case, the department was saying, you know, we're not gonna bother you, why does father take it all the way to the SJC?
He wants his name cleared.
Yeah. Remember the central registry that we talked about? He's like, I don't want to be in there, not even for a little length of time. The initial decision was where the 51A to begin with was wrong, the 51B decision was wrong, the fair hearing officer's decision was wrong, the Superior Court's decision was wrong. I want to be clear, as Norman said. What's the matter, Norman?
No, I'm sorry. I just had missed the, I have all those standards confused, but, you know, when's the next test?
So, anytime you think of an appellate court reviews. I mean, in this case, there was a review all along because you had administrative agency also reviewing. But anytime if you have SJC or appeals court, and you're asked what's the standard of review, it's going to be something like, you know, abuse of discretion, clearly erroneous. Those are the most popular in terms of an appellate standard of review. But because this particular case also involved an agency and the reviewing of an agency decision by the Superior Court, the Superior Court judge was looking at that substantial, what did you say? Substantial evidence, whether there was substantial evidence in the record. In that case, the trial judge was almost acting like an appellate court, right? Because the trial judge was reviewing the agency decision. And that's what you guys are going to do Thursday. So in your materials, you have the IFA case. And I emailed it to you as well. We're going to do, I think we're only going to have time for the IFA administrative hearing and the IFA Superior Court hearing. So the first thing we're going to do, and I'll tell you who I need for to play roles.
What do we do with Kate?
No, the IFA hearing, and I've emailed it to everybody. And it's also at the end of your reading, right after all these medical neglect cases. Yeah. Okay. So the hearing that Elizabeth was talking about in Kabul, when she summarized the Kabul case, where the hearing was in the administrative offices of the Department of Children and Families, the department officer reviewing the 51B workers' decision that this was abuse and neglect. That's what we're going to do first on Thursday. I'm going to need somebody to play the father. Write down these names. You have it on your email, but the father's name is Imani Tuma. You could just say Tuma. So I'll need a person for that. The mother's name is Corazon Tuma, same last names. I need somebody to play the mom. Then I need somebody to play the nurse. So Katie Langdon is the school nurse, and she's the 51A mandated reporter. Then I'll need somebody to play Maria Friedlander, the Department of Children and Family social worker who investigates and finds this reasonable cause. I also need the English teacher. His name is John Martineau. So for the hearing, that particular hearing which we're doing first, 1, 2, 3, I need 5 people. Any volunteers? Ashley, what do you want?
I'll be Mrs. Tuma.
Mrs. Tuma.
But you need to have somebody for Obatala and Ogun.
They're not going to testify. they're present in spirit, but they're not testifying.
Fight over who gets the goat.
Oh, you're Imani Tuma, forget it. Norman's the father.
You know, because I wear Armani clothes. And I have a brain.
All right. Who wants to be Katie Langdon, the nurse, the mandated reporter?
I'll do it.
Marina. Who wants to be Maria Friedlander, the social worker who investigates?
I want to be
Elizabeth?
an English teacher.
Who wants to be the English teacher? Alina?
Absolutely.
Okay, Alina's
Once
the-
in my life, maybe
Okay.
an English teacher.
Alina's the English teacher.
Yeah, what you wish.
All right.
I'm gonna speak Russian to you then.
Okay,
I'm
now.
gonna be a Russian.
Now, the Superior Court, all I need, because that one's pure legal argument, I just need 2 attorneys, 1 for DCF, 1 for the parents. And that's Cobble, when Cobble
So the
sued in
first one
Superior
is
Court,
the, Superior.
it's that same kind of procedure. So I need 2 attorneys, attorney for DCF to do a legal argument, attorney for Toombs.
So we're doing only one case, that's it?
Well, I'm going around the room. I still have Kelly, Alana, Lily.
Say.
Kelly will do what I want.
Yeah, doesn't matter which one.
So there's 2.
DCF, I guess. No, Toombs. And Lily's DCF. Let me think about this for a second. Only Alana doesn't have a role in it, right?
I don't.
And you don't either. Oh, perfect, because I would like to get to the, initially, I was building in time to also make this a juvenile court case and do an actual 72-hour hearing. We don't have time for a 72-hour hearing. However, let's also suppose that, that the department does in fact get custody, right? And the department gets custody, gets emergency custody, and assume, this is for your 3rd scenario, you will see on your email, it says juvenile court, 72-hour hearing, but rather than do the hearing, let's just do some quick closing arguments, and I'll use only attorneys rather than witnesses. So, let me have Danielle represent the parents for that. Lily represent the department. But I need somebody to represent the child. Who wants to go again? What did I do? Oh, perfect, Alana. All right, let me go over this, all right? So on your email, you'll have the instruction page, and you'll see all the roles there, so I'm just summarizing this right now. IFA administrative hearing. Dad is Norman, Mom is Ashley, school nurse Marina, DCF worker Elizabeth, English teacher Alina. Wait till I teach you English. Then Superior Court arguments. Attorney for DCF, Lily. Attorney for Toombs, Kelly. Then Juvenile Court arguments. Attorney for parents, Danielle. Attorney for child, Alana. That's my problem. If I had just one of you in class, I would, anyway. And attorney for DCF, Lily. Okay.
So Lily did get 2 roles, right? Because you mentioned her
Oh,
up as
you
an
did. But that's
attorney
okay,
for
because you're
Superior
the
Court.
same attorney both times.
Same.
Yeah.
Yeah. I thought that. I thought that I had.
Do we have a minute to discuss the syllabus?
Yes. Okay. So
You added us a week.
We're now. I did what?
I think you're keeping us an extra, I don't know if the school schedule is
Oh, at
supposed
the
to
end, you mean?
change. Yeah, I think it says the last day of classes is May 2nd.
Oh, yeah.
What did I do?
So I just didn't know if those were important things you wanted us to consider, or if you really wanted us to come for an extra week.
Sorry, we don't find the mirth in that.
You don't?
No.
I
Killing
won't be
us.
here, so.
Killing us.
So are you canceling those?
The dates I will.
Right.
For example, we're not doing mental health, which means that next Tuesday, you know what?
Should we read that? I mean, yeah, read, but do a read to prepare for the mental health
No,
cases?
no, not unless and until I get a speaker. If not, there'll be nothing regarding that on the final.
Okay, so that's next Thursday's cases.
Yeah, and you know what, I think I would. Tuesday the 8th, I think what I'm going to do is, so we have Tuesday and Thursday. Let me think about how I'm gonna restructure it, because there are certain, things I definitely want to have you guys do. And the question would become whether I want to do away with the student search at the end or work it in and do away with something else. So I'll let you know, guys, next week or by Thursday.
Just one more question.
Yeah.
About the juvenile law rounds.
Yes, yeah.
Are we going to start picking dates?
We're gonna start scheduling those now, all right?
Like I said, you were
Why don't you guys send me emails letting me know, actually, let me know just what days of the week you're generally available, because I think we can work in more than Mondays as well with Ilya supervising and getting you guys set to observe.
Okay, and what
Okay.
is the requirement as far as?
It's just
time?
one day, and it generally turns out to be a morning, because by the time the case breaks at 1 o'clock, generally you don't need to go back. So be prepared for, getting there about at 8:30, 9 o'clock, right, Norman? In the morning,
is it?
and finishing by 1-ish.
In Lowell.
In Lowell, yeah.
Lowell,
And
Lowell Juvenile Court?
yes, the requirements on the front page of the syllabus with the address and all of that. So sometime this week, just send me an email, say, I'm available Monday, Wednesday, Fridays, and I'll start
Do you need
making
me
up
to
the.
resend you my date, we put down the 21st of March? I had emailed you before, that was the date.
Yeah, no, you're all set.
I'm all set.
Yep. Okay, so remind me also, if we finish the hearings in time on Thursday, I'll go over the syllabus. If not, certainly next week, all right? Because we have just next week and then spring break after that?
Yeah.
Okay. Thank you.